Supreme Court held that it had authority coupled with a duty to pass an appropriate order for doing complete justice under Article 152 of the Constitution, and therefore the relief to 163 workmen would have to be molded to be somewhat similar to that given to the other group of 10 workmen, since their services had been terminated in 1985 and the case was decided by the Supreme Court on 21 October 2013, most of them must have reached the age of superannuation. Therefore, there could not be any order of reinstatement. They would be entitled to continuity of service, and although they had been receiving last drawn wages under Section 17B of the Industrial Disputes Act 1947, they would be entitled to 25% back wages as an adequate compensation and retirement benefits on par with the other 10 workmen. Inherent power under Article 142 cannot be invoked when alternative remedy is available and has already been availed of. The inherent power is meant only to correct orders when other remedy is not available. Since the remedy by way of review under the rules of this court has been provided, the inherent power cannot be invoked. In a bribery case under Section 7 and 13 of Prevention of Corruption Act 1988, the Supreme Court held, in case of minimum sentence provided by the law, it is not at all appropriate to exercise jurisdiction under Article 142 of the Constitution to reduce the sentence on the ground of so-called mitigating factors, as that is tantamount to supplanting a statutory mandate and further ignoring the substantive statutory provision for a criminal act. The power to do complete justice in any cause or matter is plenary in nature, which is entirely of different level and of a different quality. Any prohibition or restriction contained in ordinary laws cannot act as a limitation on the constitutional power of the Supreme Court. A constitutional court monitors an investigation only when circumstances compel it to do so. The expression court monitored cannot be interchangeably used with court supervising investigation. Once the court supervises investigation, there is hardly left anything for investigation. The investigation officer is only to form an opinion and the court to try the case based on the opinion of the investigation officer. In case of investigation by CBI against high-ranking officers being monitored by the Constitutional Court, there is no reason of requirement of approval by the central government under Section 56 of Delhi Special Police Establishment Act 1946.